So should there be PRA exemptions or the Public Records Act exemptions in California bills? So from time to time, we see a provision in reading bills in the legislature that might say something along the following lines. Contracts, grants, and related information created or obtained pursuant to this provision shall not be made public and are exempt from disclosure under the California Public Records Act, Division 10, commencing with Section 7920 of Title I of the Government Code. What's the meaning of this language exactly? Well, it provides an outright exemption from the requirements of California's Public Records Act, or the PRA, which of course is intended to allow public access to government records and documents. Now, by way of background, the PRA covers public records of agencies, including state and local government. Be aware that the legislature has its own law called LORA, L-O-R-A, the Legislative Open Records Act. Under the PRA, public records are defined as any writing containing information relating to the conduct of the public's business, prepared, owned, used, or retained by any state or local agency, regardless of physical form or characteristics. Now, what's the stated purpose of the PRA? Well, the law itself says in enacting this division of the government code, the legislature, mindful of the right of individuals to privacy, finds and declares that access to information concerning the conduct of the people's business is a fundamental and necessary right of every person in the state. Now, to be fair, there are already numerous exemptions in the PRA and the government code precluding public disclosure of specified information. However, in my humble opinion, a blanket exemption, such as the one I read to you earlier, appears overbroad. Hopefully, there are clear explanations and justifications for any of these outright PRA exemptions. Now, while personal identifying information, medical records, certain tax records, even proprietary information, litigation documents, those are appropriately exempt from public disclosure. And I think a blanket exemption is rarely justified, frankly. For example, documents related to contract negotiations may be appropriately withheld from the public, but why, for example, would an entire finalized contract be exempt from disclosure? Similarly, perhaps proprietary information in a grant of state tax dollars may be appropriately withheld from the public, but why would the final grant be exempt from disclosure, which obviously notes the expenditure of public monies? For example, the state discloses the award amounts and the names of the awardees for employment training panel grants, Cal Compete tax credits, and the like. So what's the justification for exempting blanketly a grant of public funds from disclosure? Again, while narrowly drafted exemptions from the PRA might be considered justified, I certainly question the necessity or the appropriateness of blanket exemptions from the Public Records Act. Transparency of public agency actions, and of course, the expenditure of public dollars should be our guiding principle, and therefore, blanket PRA exemptions I don't think are justified.